Start. Disputes are always a drawback for any industry. A dispute arises for several reasons, the most common being the relation between the laborers and their wages. It is the conflict of interests between two parties that give rise to a dispute. The parties involved in an industrial dispute are the employer and the employed. Traditionally speaking, the employees have always been placed on the lower ladder of the society by the employer, presenting a dominating self being in the position of authority. This inequality that has been existing in the industrial domain for a long time now requires settlement on the part of both the employer and the employee, having an equal opportunity to present their wants. An employee has the right to be provided with wages depending on the amount of work he delivers. It is the responsibility on the part of the employer to provide his employees with a reasonable amount of wages along with other conditions that are necessary for a person to earn his livelihood. The founder of the Australian system of arbitration and conciliation, Mr. Justice Higgins, had correctly pointed out that the conflict between wage earners and the profit creators will always be existing with us in our everyday life. It is therefore always necessary to settle the disputes arising between two parties under the Industrial Dispute Act 1947 in order to prevent the industry from facing loss or sufferings. All disputes arising in an industry cannot be resolved in the same manner, and therefore comes the concept of the mechanism of settling disputes under the Industrial Dispute Act 1947. Some of the mechanisms that are commonly utilized are adjudication, conciliation, and inquiry by the court of law, etc. These mechanisms help in settling the disputes by investigating the matter, and to successfully carry out the process, available mechanisms are utilized. It is to be remembered that industrial dispute is different from any other kind of dispute on grounds that it is something more than just getting compensated for the loss suffered. Rather, it is a constant fight against oppression on the part of those who are employed for providing welfare among other sections of the society and not being subjected to similar kind of welfare due to the authoritative rule on the part of the employer. It is correct that the dispute settlement mechanisms can provide relief for a temporary period only. These settlement mechanisms, if used effectively, can provide long-term services also. Therefore, what is necessary is the correct application of the mechanisms available for settling disputes. The Industrial Dispute Act 1947, hereinafter referred to as the Act, is an act that was formulated to guarantee fair and equal terms between the employer and the employee. The Act aims to settle the disputes that arise through negotiations. By doing so, it promotes industrial harmony and peace. The Act regulates the labor law in India as far as the same relates to trade unions. Section 2K of the Act 1947 lays down the meaning of an industrial dispute. The parties that can be involved in an industrial dispute includes employers and workmen, two employees, employer and workman. The provision also lays down the grounds that need to be abided by in order to term a dispute as an industrial dispute. 543.